Hey, it is August 3rd, 2018, and welcome to Cannabis Live. We are the attorneys of the Cannabis Legal Group. My name is Barton Morris. This is Travis. Wait. Travis and Nick. And we're going to talk about some marijuana law today, specifically with regard to the state of Michigan. Before we begin, though, I just want to make a request to anybody that's interested. Please let us know what you'd like for us to talk about. So if you let us know either through comments in this particular session, or if you're watching this on YouTube, you can make comments there. You can email us directly or message us directly on Facebook and let us know what you want us to get into, and we'll do it. There's generally a lot of stuff anyway that we can get into, but if there's something that you guys want, then we're happy to do it. Today we're going to discuss the city of Detroit, particularly because there was a lot of activity this week. On the 31st of July, a couple days ago, Tuesday of this week, there was a couple things that happened. Well, first of all, with respect, we're going to start with a court ruling. Many people may be aware of the fact that the city of Detroit was authorizing temporary operation of medical marijuana facilities, right? And and those were individuals that were applying or had applied for and received permits to be a medical marijuana caregiving center. Most of those individuals, I think there was a list of about 57 of them. Most of them were provisioning centers or retail operations, but many of them were also cultivation operations and processing operations. And so they issued temporary authorization or temporary attestations for those that are filing applications for the state of Michigan. And one of them, a company called D. Savage, operating a cultivation facility on Jefferson, was visited by the Detroit police about 2 months ago in a raid. They took several hundred plants and said that even though they were given temporary attestation to operate by the city of Detroit, they filed all the necessary paperwork with the city of Detroit and the state of Michigan. The Detroit police said that they were operating unlawfully because they weren't doing, the caregiving grow, and then charged 6 people with manufacturing marijuana. So we've been working on that case diligently, and finally and properly, rightfully so, the case was dismissed on Tuesday. And I don't want to go over exactly the reasons why, I think, but it's more important just to illustrate now is what it means, right? And to me, what it means is that what does temporary operation of a facility means? The city of Detroit, first of all, said that they didn't provide temporary authorization for cultivation, but only provisioning centers. There's absolutely nowhere, anywhere within any of the documents they issued, any ordinances or anything that said anything otherwise. So that was completely thrown out. That's just simply not true. The temporary authorization or attestations that they provided were across the board for whatever particular type of medical marijuana activities defined under the Medical Marijuana Act as a caregiver can engage in. So that was finally laid to rest. And then the question then really becomes when somebody's given a temporary attestation to operate, what are they able to operate as? Are they able to operate as temporary operate as a facility that's been identified and defined by the Medical Marijuana Facilities Licensing Act? And the answer is yes. Our clients were given the operation or the authority to operate as a licensee that they filed for, which is they filed for a Class C operation, and then they also filed for a provisioning center and for a processing. So they were giving temporary authorization to do all of these things as contemplated by the MMFLA.
I think it was a really interesting case because, as we mentioned several times on the show, and to anyone who's really ever asked us about it, temporary operation as a concept has always been complicated and not well defined, and that doesn't help the fact that, as we talked about last week on your video, the city of Detroit has had a storied history with figuring out marijuana for the last several years. And it was in that confusion that an enforcement action was attempted, and it really was, quite frankly, trying to base that decision to shut down this facility on smoke, really, because there was never, and this was emphasized based on the opinion, there's never an intent to do anything wrong. Their intent was to do what they were supposed to do. Their intent was to go get the license from Detroit, get that permission from Detroit to temporarily authorize their use, go file an application with the state. Their intention was to be compliant the entire time, and I think that's why it was an interesting case to go over and to see play out, because it'd be one thing if this was an operation that's intention was to make as much money selling marijuana as they could and try to hide behind these temporary authorization rules, but that wasn't the case. They were trying to put themselves in a position to get their state license to operate as a grower, operate as a processor, operate as a provisioning center, and the point A to point B path to get there under Rule 19, under the City of Detroit's authorizations, allowed them to engage in certain conduct. You can see, based if you read the news stories about what was happening in there, yes, they had potentially the ability to process and also potentially the ability to operate a provisioning center, but they weren't. They were growing plants, and their intention, if you look at it and just they see what was happening in there, was to lay a foundation to shift into the MMFLA. Mm-hmm. And I think that's basically why the judge treated the case as it did, as opposed to other potential temporary operation situations, because they had if I recall, there was a cease and desist letter accidentally issued that then got clarified, because when they received it, they as far as I could tell, immediately realized, hey, that's not true, and got it cleared up. And it was a lot of confusion from a lot of different areas that led to the unfortunate event of them being raided. And it's great to see that the legal team behind that, which was us and several other attorneys, were able to help that client navigate to a better position now. And it really just emphasizes transition. As we're moving from the 2008 Medical Marijuana Act into the Medical Marijuana Facilities Licensing Act, we talk about how these laws are either new in one case or have problematic, history in Michigan in the other case. We're in a transition period, and transition, there's vulnerabilities. There are people with well intentions that are going to get, do the wrong thing accidentally. There's people with poor intentions that are going to do the wrong thing intentionally. And, it's a path to navigate. So, what's important here is, if you're trying to do what you're supposed to do, it's great to see that at the end of the day, our legal system will eventually, remedy some of those mistakes.
And I think it's important too. You mentioned transition, and when they mentioned Rule 19, they talked about this was for the patients. We want to keep access to patients allowed, so we're going to let these facilities temporarily operate as we transition into the licensed regime. And I think what Laura said in a few meetings now, too, is that they really want to work with these licensees to bring them from the unregulated temporary operation market into the actual state operating license. So, and I think this is a decision by the judge is consistent with that. I think there was a lot of uncertainty and confusion, and I think that this was the best fair result based on all of the kind of new laws, unclarified things. I think it makes the most sense.
And I think it's it's easy to see why people, why the prosecution, why the city potentially might have thought that provisioning centers were the case, because it's no surprise that the primary contemplated operator for temporary authorization was, in fact, point of sale, the actual transition of product to a patient for consumption. But just because that was a big focus of discussion doesn't mean that's what the rule said. The rule didn't say we temporarily authorize provisioning centers. It says we temporarily authorize medical marijuana facilities. MMCCs, medical marijuana caregiver centers, under the City of Detroit's old definition of such, didn't say we authorize dispensaries. It says we authorize caregivers to engage in caregiver conduct. Well, caregiver conduct is more than just the point of sale. It's the cultivation of, it's the creation of product, it's the transfer of product to their patients. So when you're contemplating what a caregiver can do, and then you're contemplating what a marijuana facility under the Medical Marijuana Facilities Licensing Act can do, they're different. We've taken things caregivers can do and really split them out into 3, 4, or 5 different types of conduct that are different types of business licenses. So you can't just say an MMCC is a dispensary or an MMCC is a provisioning center. They're not. We had caregivers that could do things caregivers can do, and in Detroit at a level that was more commercial, more business oriented than in most other communities in Michigan. But under the MMFLA, what a grower can do is grow plants. What a provisioning center can do is sell finalized product to a patient. And that transition isn't one-to-one. So there was this Rule 19 temporary authorization that allowed you to do certain things and act as a facility, not as a caregiver center, as a marijuana facility. And those are two different things. So, what else would it mean? You're either a caregiver or you're a facility. And then under Rule 19, you're in a transition from one to the other. So, if you're just a caregiver, as we've seen in court cases recently, as we've seen in general, you don't need any temporary authorization. You have a caregiver card. You can engage in that conduct. What you're doing when you're not a caregiver, when you're doing something more, when you're a Rule 19 operator, you're on the path to become a finalized licensed facility. So your conduct is going to be different than a caregiver's conduct. And and it's in that waters that we found an enforcement action that needed some clarification.
Right. I do want to make it clear that we had help, right? So the other lawyers that were on the case, Michael Camoran and David Grimm, I think we all worked as a really, really good team. All of us brought something to the table that allowed us to get the result that was mandated, that was necessary in order for this to be cleared up. And everybody did a great job, including our clients too, who were really engaged in the process and were supportive in every way whatsoever. Nick, do you got any comments on what this means for provisioning centers? Like, I think that this kind of clarifies a little bit like what a provisioning center can do and what it should do under Rule 19 temporary operation.
I think the most important thing, and they always told all the temporary operators this, is that you're doing it at your own risk. And while they want to help you get into transition and get towards your state operating license, I think you need to show them the work that you're doing and be as compliant as possible as you can as you're operating as a temporary operating provisioning center. And that includes inventory, and obviously testing labs are a little bit in flux right now. Hopefully there will be one at the next meeting. But I think that showing them exactly how you're going to comply and that you already have those kind of frameworks and systems in place is definitely important, considering you're doing it at your own risk and that you want to show them that you're going to be licensed. So help them help you get licensed and don't skirt the law or kind of go outside the bounds.
Right. Just because you're temporarily operating doesn't mean that you get to operate in any manner that you wish. We advise you, anybody that's temporarily operating as a provisioning center or any other licensee, to do so in a manner that is envisioned by the Medical Marijuana Facilities Licensing Act and pursuant to its provisions, which includes testing, utilizing software for seed to sale, doing all of the things that are going to be necessary. Labeling, making sure that the product is coming from within the state of Michigan, not from outside of the state of Michigan. There's a lot of areas in which that people can be operating, and they have to be really particular about what they're doing because they are operating at their own risk. There is this transition period, and it's not clearly defined what the rules are, and therefore it's subject to interpretation, and unfortunately sometimes that interpretation can be negative if it's coming from the Medical Marijuana Review Board, and if it's negative, then that could be a fatal scenario.
Right.
I think later on, I'd like to talk about like an update as to where they are with the licenses too, because I think that we get a lot of communication with them, and so it'd be good for us to share about that as well. But first, I think we'll next transition to also on that same day, the 31st, there was the city of Detroit enacted and passed a zoning ordinance for medical marijuana facilities in the city. And just as a timeline, people may recall that the city of Detroit was accepting applications for medical marijuana caregiving centers, and then, but there was no, late 2017, there was no actual opt-in, and then people created a ballot initiative that the voters voted on and passed it, proposals A and B. Proposal A was like the actual opt-in. The city of Detroit is going to accept and have all 5 license types. But proposal B was the actual zoning, which said that allowed for dispensaries to just be everywhere and to be clustered and to be and basically to have very little regulation as to where they're going to be. And then there was a lawsuit, and there was a judge that ultimately ruled in February of this year that the zoning ordinance was thrown out. and then they had to create a new one again. That's what was enacted, right? So now we have it. I think it's great that we have it. Finally, now we can move forward with applications, which is a whole other question.
All right.
So what do you guys think about the new ordinance?
Well, I mean, it's important to remember the ordinance that was voted on in the initiative that got thrown out was passed by the citizens of Detroit by what, I think 60%. The ordinance that we have now is very reminiscent of the medical marijuana caregiver center ordinance that we had back in 2015 and 16.
It's a little more relaxed, though.
It is. It's certainly. I think they learned some lessons, but it's not going to be too unfamiliar with anyone who went through that process a few years ago. I think some of the big items are there are no caps on marijuana facilities in the city except for provisioning centers. There is going to be a limit in the city of Detroit to 75 provisioning centers. And it's also important to remember that there were medical marijuana caregiver centers, MMCCs, that are in various degrees of already zoning approval or temporary authorization. And there is a transition period for facilities or operators that were going through that process that did get the MMCC approval or zoning approval to have a shot to transition into provisioning centers. It's not automatic, but there are roughly 60 or so, 60 to 70 people that had the opportunity to be temporarily authorized in Detroit. Now, it's unclear how many of them want to remain as provisioning centers. It's also how many, it's also going to be very difficult, I assume, for a lot of them to get through the board at the state level. So I imagine a lot of those slots will open up again. But if you were an MMCC, if you are already authorized under their old ordinances for a zoning slot, especially in those industrial districts, which I mentioned before, where you used to be able to cluster some of those businesses, you do have an ability to, I don't want to necessarily call it grandfather yourself in, you still have to go through several processes, but it is, they did acknowledge that, your previous approvals will give you some sort of advantage if you've been trying to be in the marijuana space for the last several years in Detroit. For anyone who is now looking at Detroit from, wanting to get into this new market, I think there'll be plenty of opportunity there as well. But just like in most of our larger municipalities, we are going to be dealing with a cap at provisioning centers. When it comes to zoning locations, it's still very similar under the old ordinance, as I said. We still have a definition of drug-free zone. It's a 1,000-foot buffer from quite a few different types of uses, and those are the same uses they used to be: child care centers, educational institutions, libraries, basically parks, but what they call outdoor recreational facilities, schools, youth activity centers, public housing.
You got rid of arcades.
They did get rid of arcades.
Not that there were too many of those around the city.
They were more than you'd think, but they didn't usually seem to be in the locations that that most of that files I worked on anyway. But so those are still there. And for growers, processors, secret transporters, safety compliance facilities, your only real restriction is being in the appropriate zoning district that's outlined in the ordinance and being 1,000 feet away from a drug-free zone. Beyond that, those are really the zoning buffers to keep in mind. If you have a facility, it's right next to another facility, there's no buffers there. For provisioning centers, it's a little more strict. There is a 1,000-foot buffer between two different provisioning centers. Unless you are in that situation where you've already had your zoning approval under the old set of laws, previously the industrial district allowed for some type of clustering in those M districts in Detroit. That was removed. You're no longer allowed to be within 1,000 feet of each other if you're both new businesses coming at this for the first time. So there is going to be additional buffers there for provisioning centers. In addition to that, just like before, churches and what they call controlled uses, but are effectively liquor stores, are still buffers for provisioning centers, not the other license types. So those are really the big overviews. There are still some overlay districts that would zone you out as well. Traditional Main Street overlay, and the other one's called the Gateway Radial Thoroughfare. They do have some maps on the city of Detroit if you dig deep there to see where those areas are. In my experience, they're usually not factors unless because a lot of those locations are places the city of Detroit's already putting a lot of emphasis on to develop anyway.
Kind of the main hub is in roads over the street leading to the downtown area.
So the other, they do allow co-location. So some of these zoning districts overlap for growers, provisioning centers, and processors. You need to, just like you would anyway, need to meet all the requirements of those zoning districts, all the requirements of this ordinance for when it comes to how to design that facility. But beyond that, there is a new kind of building footprint kind of cap on certain types of parcels in the city. If your parcel is less than 3 acres, the maximum square footage footprint you can have in the state of Detroit for your facility is 30,000 feet. If you're square feet, sorry. If you're larger than 3 acres, and I think it's 3 to 5 acres, then you can be up to 50,000 square feet. So there are some for growers and processors. There are some new considerations when it comes to. There are some new considerations when it comes to, the type of facility they want to see there. And there are some caps on the size they want of these facilities. I think the intention behind that restriction is to save some of those larger buildings for other types of industrial uses they want to see in these districts. As exciting as marijuana is, the city of Detroit likely wants to see other types of industries focus on the city as well. The one that springs to mind is probably automotive and some of the other things. Mm-hmm. So, that's a quick overview of these restrictions. Some of the items that you might be familiar with from Detroit's old ordinances, there's no longer really a variance you can seek. There used to be this concept of a 10% variance. While variances in general, I assume you can still pursue like any industry can, there isn't an enumerated like 10% like wiggle room that used to be under the MMCC ordinance. And there are just straight up prohibitions on the Board of Zoning Appeals from creating variances or restrictions from their drug-free school zone, which we've seen enforced before.
All right, so Nick, why don't you tell us about the new review committee?
Mm-hmm. Yeah, so previously under the MMCC ordinance, you would apply to BC, they would do a zoning review, you would have site plan approval and a special land use hearing, and then in most situations you would be near somewhere and you would have to go to the BZA, and that's kind of how the MMCC ordinance and the application process would play out. With the MMFLA ordinance now, what they've done, so they've set up what they call a medical marijuana facility review committee. And that contains one representative from 9 or so different departments and agencies inside the city of Detroit. So the head of that department or agency will appoint a qualified representative and one alternate. And what they'll all do, the 9 or so of them, and it's headed by the law department, is that they're charged with reviewing and making recommendations to BC based on the application that you provide. And so there's a lot of application requirements, which I think we'll get to next. But basically, it'll be an online application, and you submit it to BC, and they do your zoning. If your zoning checks out, then they forward your whole entire application to the review committee, and they do a thorough review. They all come from different specific expertise within the city of Detroit: planning department, police department, public works, BC. A lot of those different areas that will be reporting on the different narratives and things in your application. One of the really unique situations in the application, or in the ordinance, is that the MMFRC needs to unanimously approve.
What's the MMFRC?
The Medical Marijuana Facility Review Committee. They need to review and recommend unanimously to permit your facility. And so if they don't, then the recommendation is basically to deny. And so what will happen after that is you'll either get approved or denied, and then your application goes back down to BC for kind of a final review at that conditional land use hearing. And so they'll kind of look at the recommendation from the facility review committee and give you a yes or no on your application.
Hold on. What do you guys think about this unanimous approval, right? Like there's at least 9 different departments, which includes the fire department, the legal department, the Department of Public Works, BC, the city assessors. There's at least 9, and then it says that it could be more than that. So everybody's got to agree. If one person says no for whatever reason, then they're going to recommend a denial. But to me, that sounds a little bit.
That's
crazy.
True, but you have to remember the final decision is on another department. So if we start seeing a pattern in practice,
the BC, right, who also has a representative.
That's true.
On that board.
So if we start seeing a pattern in practice of this review committee denying every applicant, it would, at least that's not the final say. You'll have another opportunity to present your side of the story to the final decision makers. But you're right. I mean, it's a lot of voices in a room, and it doesn't matter what you're doing and what the topic is. It's going to be hard to get that many people to unanimously agree to anything.
Does this mean it's going to be more subjective than objective? Because that's what I'm concerned with. I think a lot of people are concerned that they're going to do everything that they have to do, and then one guy says, no, I don't like it for whatever reason. If there's so many people that are having a say, it just means that there's more people that are going to potentially interfere with an appropriate
That is true.
Feel it.
It's certainly an opportunity for some politics to sneak into what should be an objective, decision. But I guess we'll have to wait and see how they play it out, because this is a new board. They've never done this before, and it'll be interesting to see who are those representatives that make up the review committee, and what kind of goals they're trying to accomplish through the power delegated to them. Mm-hmm. If we see on our state level board, some motivations becoming pretty clear about what they're trying to accomplish in applicants. But I think just the city of Detroit should keep in mind, just like every municipality should keep in mind, that ultimately at the end of the day, the state of Michigan is going to pick what operators get a license. You certainly have a say in that, but the design of the MMFLA is how many different types of businesses are you allowing, where are they allowed in your city. Just because you get the city of Detroit's approval, whatever that approval is, does not guarantee you in any way you're getting a state operating license. You have to submit step 1 and press. You have to submit step 2. They have to inspect your facility. They're going to deep dive your criminal and financial background check at the state level. So if the city of Detroit wants to create a bottleneck and arbitrarily deny an application, which we don't know if they will. We'll have to wait and see what they do. But if
I'm not saying that they will.
Of course not. But if that's obviously my concern as well when you see a minimum of 9 people on a committee that needs to reach a unanimous decision. So let's talk about what they're looking for, though. I mean, it's some of the usual suspects here, but there's some telling criteria required. You need a site plan, you need a floor plan, you need a business plan. But some of the things that jump out to me are, community benefits, the types of investments you're making in the city of Detroit, how many or how many contemplated members or constituents of the city of Detroit you intend to employ. So, the design that I'm seeing, in addition to some of the normal things I expect to see, are, what's important to the city of Detroit in the design of this ordinance is to benefit the city of Detroit. Show how you're going to be a member of that city, how you're going to, have an impact in a positive way as you operate this business in the city of Detroit.
And I think that's always been how it has been in Detroit. I think through the MMCC process and even before that, just in every general establishment of a business in Detroit, they want to know if you're going to contribute to the neighborhood, if you're going to improve blight, if you're going to be a contributing good neighbor to the whole city and the local community.
Was there something in that required, or that suggested that they wanted Detroit residents to be employees?
Yeah, a number of anticipated or expected employees that are Detroit residents. No, not on the previous one. Definitely these community relations and the actual, lining up how many in Detroit you're actually going to hire is definitely new.
Right, and we're seeing some chatter about what the city of Detroit is trying to accomplish here, and I appreciate frustrations, but just keep in mind, there's owning the license and there's benefiting from the license. Just like someone owning the license is going to have as a criteria for that path to get there, have a community impact on Detroit, employ people from Detroit. There are significant opportunities being a key member of one of these operations that don't necessarily require you to hold equity in one of these businesses. If you're good at growing or you bring something unique to the table, you can be a very important element of that operation without necessarily being the owner of that operation. You can be a key employee, you can be a key manager, you can be someone that makes that business as great as it potentially could be. And, those are the types of opportunities you shouldn't get blindsided by or tunnel vision on. If you're feeling like, as I've seen some of the communication, that this isn't an opportunity you personally can pursue, maybe you just need to look at other opportunities this could potentially create. There's going to be businesses that need to hire good people and compete in the city of Detroit. And how are those businesses going to distinguish themselves? The ones with the best people, the ones who want to be in Detroit, the ones who want to make that business the best it can be. And some of that is going to be the owners of these businesses. Others are going to be the ones who work for those people. And just like I work for Barton, I do my best to make this the best, job I can have, the best firm we can have. And don't just assume, this isn't an opportunity for you too, regardless of what your perspective is in Detroit or in the MMFLA in general throughout the state of Michigan.
I want to make, we're going to wrap up on this particular issue real quick, but I did want to make a comment on that. I see a lot of new applications from other cities trying to include the MMFLA requirements, right? Some cities, like the city of Grand Rapids, says that they want to see a completed step 1 before they'll consider an application. Other cities are like, we would like to see some of the same documentation, same capitalization, or same even operational narratives that the state of Michigan is requiring. So I found it to be interesting that the city of Detroit in this ordinance only seeks to require one thing that's similar or identical from the MMFLA, which is capitalization requirements. They're not requiring step one approval, which we believe that they shouldn't. We don't think that any city should do that because that's a whole other set of problems. And they're not requiring anything with respect to like operational plans. They definitely want a comprehensive business plan, which it's going to be comprehensive.
It'll contain a lot of the similar narratives that you will put in your step two, but they're not saying give us your step two facility plan and security plan. So a lot of that stuff will probably be able to be used towards that, but they're not saying an official step two.
And I mean, I think it's perfectly reasonable for a city or a township to want to see your step one and see your step two. I mean, but that doesn't necessarily mean that should be an application requirement at the local level. I think that's the trend we're starting to see. I think there seems to be this fear of municipalities that if they approve someone, they're stuck with them. Well, guess what? They have to go to the state and get a license. Like, just because a city authorizes a location to have a marijuana business in it doesn't mean there's a marijuana business that's going to open up. The state requirements are significant and are going to put that operator through the ringer to make sure they're ready to do this and they're going to do this responsibly. And, you know, I appreciate that you want good people in your city, but it's very difficult to get through the state review process and have some skeletons in your closet.
Let's talk about the state review process to finish up. Do you guys have any comment regarding the types of notices that we've been receiving from the department with respect to an identification as to how they are proceeding with these applications?
Yeah, I think, you know, the state is learning to ask the types of questions to find the evidence or the types of things they expect to see. If you are presenting a business with a group of operators to the state and there's a history of engaging in conduct, you know, there's questions that are raised, unfortunately. You know, if you were engaged in the old marijuana markets, you either need to acknowledge that or they're going to assume it's there and you need to either explain, you know, why your numbers are what they are. I think the biggest problem is indirect, right? What's happening is everyone at the state, and I think they've been very reasonable in understanding that, you know, it was difficult to be a caregiver and engage in conduct. That makes it difficult to, you know, financially, to show on your taxes, to do the types of things that you should have been doing. And I don't necessarily think that if you haven't, that's going to be a death knell to your ability to be in the MMFLA. But I think what is problematic is when the state sees, for example, as was a discussion topic before, if you show a bank account with significant amounts of money moving in and out of it, but your tax returns show you had no income, there's a discrepancy there. You know, income is income. Did you make money doing this? Why didn't you pay taxes on it? It's not about marijuana at that point. And that's why we see denials about that. But we all can understand it's difficult. It was difficult and unclear, and quite frankly, you know, no one really knew how to demonstrate the type of income you should have been having and how to reflect that appropriately on the records that are not required for the MMFLA. And I think the lesson is, you know, if you were in this industry, you don't need to go running straight into you know, the step one. You take some time to think about what the requirement documents and evidence you need to submit are, what that's going to look like to a, you know, administrator that needs to review it, and ultimately a review board that needs to review it. And if there are issues there, you know, you should anticipate those so that they don't blindside you when people have questions about them, right? I mean, if you are showing thousands and thousands of dollars moving through your bank account every week and you're claiming $10,000 on your taxes, anyone's going to have a question about that. It doesn't matter why that money was in your account. It just so happens this is a marijuana review board and not, you know, a gambling licensing board or a liquor licensing board. I mean, that's still going to be a problematic item. So, you know, that doesn't mean it's not something you can mitigate or you know, create an explanation for, and it doesn't necessarily mean it's going to be detrimental to what you're ultimately accomplishing. But don't just, you know, be unprepared to answer that question, because that's going to be ultimately unsatisfying to the board. So what we really need to do is, and that's not just for caregivers, that's for any type of history you might have. Just because step one requires you to submit thousands of pages of evidence doesn't mean that they're not going to look at it. What are you submitting to them? What kinds of questions would you expect the state of Michigan to have about what they're seeing? That's the whole point of this board. And what they're now starting to do is be a little more articulated about the types of follow-up questions they're going to have. And we're starting to see the types of questions we're seeing. And depending on what your position was in the past, some of those questions are going to be easier to answer than others.
Mm-hmm. Yeah, I think that as everyone's been going through this licensing process, they're learning, and I think Laura's identified a list of certain questions that they continue to ask different operators, not just singling one out versus the other. What we've seen is it doesn't matter if you have been temporarily operating or if you haven't been. They're asking these same questions to every operator to kind of dig deeper. It seems like they're trying to push along a lot of these applications in, those temporary operators in anticipation of September, but just the general urgency and willingness and ability to push these through is something we've been seeing, and I think this is just another part of the process. Through investigating and reviewing all of these tax returns and the questions they continue to have, they've just started asking these of all operators, and depending on what the answers to those are, it might impact your application decision or it might not, and I think it's just important to thoroughly explain it regardless and be as truthful as possible as you can on the application.
I see that the regulators are definitely trying to get through the temporary operators. We see like specific comments from them saying we want to get this through by September 15th, and so I see a specific intention with respect to doing that, which is great. And I think that once they do that, I think things will probably speed along a little bit with other people. But I think that they're trying to get through the temporary operators that filed before February 15th. All right, thank you guys very much for watching. Thank you, Jared and Raleigh, for the shout out and for everybody's comments. This show and all of our shows will be on our YouTube channel, and please feel free to comment on that channel as well in order to get our feedback. We'll answer questions on that or on Facebook, and we'll be here next week. I won't be here. I'll be out of town.
Looks like me and Nick will have a great show for you next week.
Yeah. And if you have any suggestions as to what type of what you guys want to talk about, then we're happy to hear it. So thank you guys very much, and
thanks, guys.
And have a good weekend.